The more you know. City Council voted on April 22 to postpone the phasing plan until May 20. We think it should have been postponed until after the Oklahoma Supreme Court ruled on our Arena TIF petition. Hear what Rob Norman, the attorney representing our right to vote, said about the city attorney's view on this. Looks like we need to ask for another legal opinion.
Or whatever the court thought the appropriate remedy was. So, by postponing it, again, you're giving yourself a little bit of time, and I understand there is some concern about the pending issue with regard to the referendum petition. My comment on that would be that's a totally separate issue. This issue is with the tax increment authority. The referendum petition involves the ordinance, and the tax increment authority does not have the authority to approve an ordinance. It's a separate development agreement. This is pretty much a routine matter with regard to approval. It's not going to impact how that case gets resolved one way or the other. But given your motion, again, the potential consequences are if you don't approve it within that 30-day time period after receiving notice, that could be difficult.
I know you all won't answer the question, so I'll answer it. The answer to the question is yes. Absolutely yes. You don't have a phasing plan without an ordinance. Otherwise, you just could have passed a phasing plan. You don't have an economic development agreement without an ordinance. You don't have a project plan without an ordinance. What the law on this point is, with all due respect to the city attorney, in my opinion, he's got it dead wrong. And maybe we're going to have to resolve that. And the people who are the sovereign here will resolve that. If you look at my letter, once the referendum power has been invoked on a city ordinance, so long as the referendum process is pending, the subject matter, not the little four corners of the ordinance, you can't splice them down into different components. The subject matter of the city ordinance is entirely withdrawn from further consideration of the legislative body of the city. And I don't think that you can splice your way away from saying, well, we're wearing our hats as Natifa, not the city. No, you're still the legislative body of the city. There's a reason for that rule. And the reason for that rule is to keep y'all from tinkering with the subject matter of the ordinance while it's pending referendum. The people are the sovereign. You're the trustees. Your power is suspended right now. You can't approve it. You can't disapprove this. I would say constitutionally and jurisdictionally, the most you can do is postpone indefinitely until the referendum process is over. That is it. Beginning, end of the story. You can't splice and dice this into different things. Now, what happens if you postpone and approve it? What happens if you do approve this thing? I think you've seen in my letter what you've just done is you've given them an argument that I don't think is very good here, but yet nevertheless, you've given them an argument to start some more litigation and say they have vested contract rights under the United States Constitution that trump the referendum petition, that trump any effort on the part of the new council to put this to a vote of the people. Make no mistake, folks, the developers and the opponents of this now realize they're kind of coming about February 12th or 13th. They came to the conclusion, hey, they looked at the election and they decided, you know, if we lose this referendum petition case, we lose and it goes to the vote of the people.
Please ask your ward council member to call for an external legal opinion about postponing the phasing plan. And remind them that we still want to vote on it, no matter what.